Welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest today is Robert E. Temmerman Jr., who I'm just going to call Bob. And Bob is an attorney specializing in estate planning, incapacity planning, and estate and trust administration. He is the managing partner and founder of Temmerman, Silly, and Coleman LLP in San Jose. Bob received a BA in Economics and Political Science, magna cum laude, from Boston College in 1975, and his Juris Doctor, magna cum laude, from Santa Clara University in 1980. He is an active speaker in the estate planning community, including the Jerry Kasner Estate Planning Symposium presented by the Santa Clara University. He also speaks for estate planning councils, bar associations. He is, what you said, the chair for ACTEC this year?
I'm in my last year as being state chair for the American College of Trust and Estate Counsel for California.
Okay, thank you for that. He has contributed chapters to books, including California Estate Planning, which is published by Continuing Education of the Bar. He has also participated in writing the rules of the court for Santa Clara County Probate Court. So Bob is one of our local gurus who's really, as you can tell, actively involved in even creating the rules for us here, and very knowledgeable. On a more personal note, Bob is an avid cyclist. 2013, he rode his bike in the Pyrenees. 2014, he was riding in the Alps. In 2015, this year, we rode a portion of the Continental Divide from Wyoming to Canada. So good for you, Bob. And also, he plays amateur adult hockey. And he tells me that he's limping the next day, but he's still doing it. So, wow, fantastic, Bob. Okay, so today, Bob and I are going to be talking about the situation where I'm a trustee, now what? And many of us, all of us are in the situation that someday we're going to have a loved one pass away or a dear friend, whatever. And there's a possibility we may be nominated as a trustee. And so I invited Bob here to share a little bit about what are the duties for a trustee, what's involved in this process, and to find out a little bit about it. These days, particularly in California, we're pretty educated, I think, and so an awful lot of people have these revocable living trusts. Most of them are pretty good. Some of them aren't so good. And so it's good to get this type of information. Related to that, though, I want to caution our viewers. Some of you are outside of California, residents of other states, even other countries, maybe in some cases. The rules can be different from place to place, and so you definitely need to consult with an attorney in your own community, and we want to encourage you to do that. We're not here to really practice law today. We're here to have a conversation that is to encourage you to have a conversation with your own attorney. Bob, thanks again for joining me today.
Mike, thank you for inviting me. It's a pleasure.
Okay. Well, Bob, a lot of people think that, wow, I've made this living trust, or Mom and Dad made a living trust, and so nothing needs to be done, right?
Well, Mike, if you're a trustee and one of your parents passed and they named you as the successor trustee, a fundamental mistake would be to assume that very little, or if anything, needs to be done. There are quite a few requirements that California law, as well as the law of most jurisdictions, impose on a trustee. So there are duties and responsibilities, and to think that there really isn't much to do would be not just a mistake, but probably open you up to some sort of potential liability to the beneficiaries of that trust.
Right. So, I mean, I think you and I have both run into situations where people haven't done much of anything. Years later, they sort of wander into our office and, well, what's this? Well, my mom and dad passed away 10, 20 years ago, and well, we just never got around to changing the title of the house to my name.
We call those stale trusts, and that part of that process starts at the educational level with the client. Whenever we draft a trust to keep us out of court in the event of death, we always advise our clients that that doesn't mean that it ends and there is no need for court supervision or any involvement. All it means is there will be a transition when you, client, as the initial trustee of your own revocable trust, becomes incapacitated or dies. And that transition of what we call a fiduciary role that the trustee is in takes place either at incapacity or at death. And it's important to recognize that there are responsibilities and duties. And if you do nothing, you're probably going to create a huge burden down the road to the intended beneficiaries, making up tax returns for years that were missed, things of that nature.
A big cleanup project.
It's a huge project.
Okay. If the decedent had a living trust, does that automatically mean that no probate is required?
Mike, if one creates a trust and the key part of this "and" is funds the trust, the assets that are inside that trust of the decedent don't have any requirement for court supervision or what we would refer to as the probate process, which is a court-supervised process over the decedent's assets. So assets that are properly funded in the trust, yeah, there is no need for mandatory court supervision. The problem that we've encountered, and I'm sure you've encountered, is frequently clients create the trust, but they don't always transfer all of their assets into the trust. Sometimes it's on purpose, sometimes it's by oversight. Sometimes they've acquired assets in the future and didn't properly take title. So post-death, the cleanup is making sure we have all of the assets that properly belong in the trust titled that way so the successor trustee can manage those assets and distribute them in accordance with the intent of the settlor or the creator of the trust.
Right, okay. What is community property and why is that status important for trust administration?
The definition of community property is important only as to husbands and wives or married couples, because community property is the property over which you acquire during the course of a valid marriage by one's time, labor, effort, and skill. And under California law, you as the creator of a trust can only dispose of what you own, and you only own half of the community property. You own 100% of your own separate property. So distinguishing assets that I owned before marriage with assets that we acquired during marriage as a result of time, labor, effort, or skill is important as to, all right, well, what can my trust operate on? It can only operate on, I can only control my half of the community and my separate. So characterizing assets, at least for married couples, is a very key component. And oftentimes in drafting estate plans for clients, we will have a property agreement so that we delineate exactly what is community and what is separate, so that there is no confusion at the time of death.
Okay. Are there significant legal fees for administering a trust? Does having a living trust really save legal and administration costs?
Excellent question, Mike. In my experience, I typically will opine to clients that generally you're going to save about 2/3 of the cost and expense that you otherwise would have spent if you had to go through a full probate. So a living trust, while it minimizes and makes it more efficient to administer an estate at death, it doesn't eliminate costs. It just reduces them, in my opinion, significantly, particularly if the trust is well designed and properly funded.
Okay. What is the significance of a death certificate and a trustee certification?
Let me take those one at a time.
Okay.
When one dies, there are oftentimes assets inside the trust, and frequently there will be assets that are outside the trust. The most common example of assets outside the trust would be such things as IRA accounts, retirement accounts, sometimes some joint tenancy bank accounts. So the importance of the death certificate is to make certain, to the satisfaction of the financial institution, that the account one of the account holders is deceased and it now belongs to the surviving account holders. For an IRA custodian, it shows the institution that the participant of that plan is deceased and they can now pay it out to the beneficiaries of record. All financial institutions are going to require a death certificate. So that's the first thing we have to get. With respect to the certification of trust, it is another document that we use with financial institutions and title companies that evidence the fact that the trustee is now indeed the acting appointed trustee under a trust. A certification of trust can be done under California's probate code, and institutions are required to rely on it, or they may have to pay attorney's fees if we have to get a court order compelling the institution to rely on it.
Okay. So many times you need to have access to cash after a person passes away. You have to pay funeral expenses, even the retainer of the attorney, and so forth. So is the access easier when you have one of these trusts?
The access is much easier when you have a trust and the assets are properly funded in the trust, because then I just need the death certificate. And in most cases, I can get a death certificate frequently within a few days, now sometimes a week, and in some cases of unusual circumstances of death that may be longer. But we can do a trust certification and oftentimes obtain access to cash much quicker than we otherwise could through a probate process.
Okay. Here's the good one. If you're nominated as a trustee, do you have to accept, and what are some things to think about in this process?
So when the creator of a living trust names you as the successor trustee, the person that the individual trusted and said, I know this person will do a good job. The question that we ask our clients is, this is a voluntary appointment. You have no obligation to accept. You can decline the nomination. And the reasons you might want to decline is because you do not have the time available to do it, your health isn't such that it would lend itself to really carrying out all of your responsibilities, or just personal reasons that would indicate, no, I'm not going to be a good trustee, or I don't want this case because the beneficiaries are very litigious. We've oftentimes counseled clients that if you're named as a trustee, I want you to think of yourself as having a big bullseye across your chest, because there will be shots taken throughout the trust administration process at you, and you will be blamed. Frequently you are not thanked, you are blamed for all the wrongs that the creator of the trust may have done to these particular children or other beneficiaries.
So, bottom line, it's a big job, and it is very time consuming, and so it's something that you don't do lightly. You don't accept this lightly.
My first role as counsel for a trustee is to try and discourage my client from serving, but once they say yes, my second role is to then keep them out of trouble.
There you maybe you can talk for a few minutes about notice requirements that apply for trusts.
We have certain notice requirements. There's a notice under the California statutory scheme that says when a trust has become irrevocable, we have to provide, the trustee must provide notice that the trust is irrevocable, that the name and address of the trustee, and you have to give a warning to the beneficiaries that there's a period of time for heirs and beneficiaries to file a challenge or a contest of that trust instrument, generally 120 days from the time the notice is transmitted. So that's one notice that the trustee must give, and they have to do that fairly readily after death when that trust becomes irrevocable. There are other notices that statutes impose upon trustees. Notice to the Department of Health Care Services in certain circumstances, notices to the Victims' Compensation Board, notices to the Franchise Tax Board. So there are various duties and responsibilities that a trustee has following the death of the creator, when typically a trust may very well become irrevocable.
Okay. Does having one of these trusts mean it takes less time to administer the property after a death?
In our experience, it does. The alternative to a trust is the probate process, where you have a will, and upon death, your will is subject to probate. Probate has certain timelines. You cannot close an estate any earlier than, at earliest, 4 months after the appointment of a general administrator or an executor. In a trust, there's generally no such requirement. We can begin making distributions without court orders pretty quickly after death when we have available cash. We can make sure we've set aside sufficient reserves to pay creditors, funeral expenses, things like that. But the timelines that are very, very code compliant in a probate don't apply. We can move that administration along. And I've actually opened and closed some administrations with one client meeting and in under 2 months
Wow.
following death.
Yeah, it's pretty amazing. Are additional trusts typically created from a single living trust? And what are maybe some of the purposes of those trusts?
Well, the answer is, in many, many cases, the creator of the living trust, which is just one trust during lifetime holding the assets of our decedent, that decedent wants their property to go a certain way. And that may mean at the first death, the estate is divided into one or more trusts. And it may mean if there's children living, they may have a trust for a disabled child or a special needs child, or they may have another educational trust for a different child. So there are a variety of reasons why the settlor is defined as the creator of the trust, may very well set up a number of sub-trusts following death that will continue on for either a set number of years or sometimes for the lifetime of a child. The primary reason for this is management and control of those assets during the beneficiary's life. They didn't feel comfortable just giving those assets outright, and hence they create a trust for the benefit of the beneficiary.
Okay. For my personal accounting, I just write total deposits down in my checkbook, or I can tell you my wife does. Some people don't even keep a checkbook at all these days because they're just, they're online, and so, anyway, is that okay for a trust?
For a trustee, one of the fundamental duties of a trustee is to account to the beneficiaries and to provide periodic reports to the beneficiaries. And an account to the beneficiaries can take a variety of different forms. We've done such things as informal accountings, where we provide the beneficiaries checkbook register, the bank statements, and ask them if they have any questions. But more formally, in order to really protect our trustee, we will do formal accounts. Mm-hmm. And California's probate code requires that they be done in a certain format. So we account for every penny that comes in and every penny that goes out during the period of the account. Sometimes they are waived. The beneficiaries don't want to go through the time and expense of an accounting, and they will waive the requirement. But my job as counsel for the trustee is to protect my client. And if I don't ever do that accounting or I don't get that waiver, my client is never off the hook.
Right. So related to this, just a little hint, is it's a good idea when you make a deposit to basically make a copy of all of the checks that you're depositing, and that'll make the process a lot easier down the road. Do trusts have to file income tax returns?
Good question, Michael. During the time that the creator of the trust is alive and that trust is revocable, it is considered what's called a grantor trust, and we ignore the trust for income tax purposes. The creator still files his or her personal income tax return, a Form 1040 and a California Form 540. But following the death of the settlor of the trust takes on a new role. And when it transitions into an irrevocable trust, we now have a separate entity or entities. And the trustee of those entities must file fiduciary income tax returns for the trust, California Form 541 and a federal Form 1041. So during the period of time the trust is irrevocable, the trust is a separate tax-paying entity. Now, it may not pay tax. If we distribute all the income out to the beneficiaries, the trust, like a partnership, is just a pass-through entity. But it does have to comply and has to file the fiduciary income tax returns, and the trustee must generate the Form K-1s that pass out and show the beneficiaries how much income and deductions they need to pick up.
Okay. Are all trusts required to file federal estate tax returns after a death?
Well, a federal estate tax return is a return of a decedent's estate. And a decedent may have assets that are in the trust, may have retirement accounts outside the trust, and may have other assets. And currently, as a result of the American Taxpayer Relief Act of 2012, the threshold for having to file that Form 706, which is an estate tax return, is now $5.43 million. Mm-hmm. So if the totality of my assets that were owned by the decedent are less than that, the trustee need not file that return. If they're close to that, or they exceed that, you have 9 months following death to have that return filed. You can frequently get an automatic extension of 6 months. But the answer is yes, you do have to file if the estate is large enough.
Okay. How about portability? Maybe you can talk a little bit about what it is and how it interrelates with this estate tax filing requirement.
So for larger estates, Mike asked me about portability. Portability is a concept that is relatively new in our tax law. It came in 2012. And it certainly gave us as planners the ability to make life simpler for our married clients. It allows us to advise our clients to say, look, I can now have an estate plan that says I am leaving everything to my surviving spouse. And even if he or she would have an estate now in excess of that $5.43 million threshold, I can use some of my exemption and transfer that or port it over to my spouse. So portability allows me to keep life simple and pass property outright to a survivor. It allows me to use my unused exemption and give that to my survivor. So for an example, this is probably the best way to try and understand it, is if I have a $3 million estate when I die and I leave my estate to my spouse, but I want to leave some of it to my children, the part that goes to my children will use up some of my exemption. What I don't use of my exemption, say it's $2 million, I can move that over to my spouse. So when my spouse passes, she'll have her $5 million plus my $2 million, and that's indexed, at least my spouse's exemption's indexed to inflation.
Okay, Bob, we don't have a whole lot of time, but maybe you can talk for just a minute about trust modifications.
This is what I kind of call the big whoops. We are approached by a client, we review the terms of the trust, and it's clear that there was a mistake in the drafting or the design of the trust. Hopefully, we didn't make that mistake, but we are assisting our trustee. California law and the law of most jurisdictions will let us seek a court petition to attempt to modify a trust. Clearly, if we have the consent of all the beneficiaries, it's fairly routine with certain exceptions. The plan here is, the best example is the decedent's trust only says give away 90% of the estate, but 10% there's no dispositive provision. Clearly a drafting error and something that we can fix. So we are fixing estate plans quite a bit in a post-death context. Can be done, generally has to have court orders to do it, but not impossible to do.
Yeah. So a lot of people think because it's now supposedly an irrevocable trust that it can't be changed. But in some situations, it can actually be modified. And now there are some income tax and estate tax reasons for possibly making some modifications to trust.
Sure. One of the provisions are if the settlor couldn't have anticipated the circumstances, that gives us a grounds to go into court. And so with the tax law changing in 2012, I don't think one of my clients really knew. None of us can predict what Congress will do. And so they may have designed an estate plan one way based upon what they thought the tax law would be, and then the tax law changes. So at least we have the framework in California to allow us to seek a reformation or a modification that changes the terms of the trust.
Okay.
I don't want to say it's easy, but it's not impossible.
Okay, we're all out of time. Bob, thanks for being my guest.
Pleasure, Michael.
Folks, hopefully we've given you some things to think about and talk to your attorney about. We'll see you next time on Financial Insider Weekly.